Wisconsin prisons shredding justice? The controversial legal mail policy. Is Wisconsin's Department of Corrections, DOC, shredding more than just paper? A controversial policy of photocopying and shredding legal mail is raising serious questions about attorney-client privilege, timely access to justice, and the potential for abuse. This isn't just about mail, it's about fundamental rights. Give a like and subscribe. Leave a comment. Effective September 10, 2024, the Wisconsin DOC implemented a policy to photocopy and then shred legal mail sent to incarcerated individuals. This policy targets mail from attorneys, law offices, court clerks, judges, and even elected officials. The DOC claims this is a necessary measure to combat the influx of drugs into correctional facilities. The process involves incarcerated individuals watching as their legal mail is copied. They are then allowed to review the copies, while the original documents are shredded. The entire process is supposedly documented using the facility's camera system. But is this enough to safeguard sensitive information? The Office of the State Public Defender, the ACLU of Wisconsin, and numerous defense attorneys have voiced grave concerns. Their worries center around three key areas: confidentiality, timeliness, and accuracy. These aren't just hypothetical concerns. They represent real threats to the legal rights of incarcerated individuals. The core of the issue is the potential for prison staff to view confidential attorney-client communications during the copying process. While the DOC claims cameras and specialized copiers mitigate this risk, the reality is that human eyes are still involved. This raises serious questions about the security of sensitive information. The potential exposure of privileged information could have a chilling effect on incarcerated individuals' willingness to cooperate with their attorneys. If they fear their communications are being monitored, they may be less likely to share crucial details, hindering their defense. This directly impacts their ability to receive fair representation. The photocopying and shredding process inevitably leads to delays in mail delivery. These delays can be significant, potentially impacting critical court deadlines. Imagine a crucial document arriving late, jeopardizing a defendant's case. These delays also make it difficult for attorneys to build strong relationships with their clients. Effective legal representation requires open and timely communication. When that communication is hampered by bureaucratic processes, the attorney-client relationship suffers. The risk of lost or miscopied documents is a very real concern. Copying machines are not infallible, and human error is always a possibility. A misplaced page, a blurry image, or a completely lost document could have devastating consequences. Even seemingly minor errors in the copying process can have a significant impact. A misspelled name, a misread date, or a misinterpreted phrase could alter the meaning of a document and undermine a defendant's case. The stakes are simply too high to tolerate such risks. The Wisconsin DOC defends its policy by claiming it's a necessary measure to prevent intoxicating substances from entering facilities. They point to a partnership with a company to photocopy personal mail and claim a decrease in drug incidents since the policy's implementation. But is this justification enough to outweigh the potential harm to legal rights? According to DOC spokesperson Hardicke, the DOC is not aware of recent concerns from the Office of the State Public Defender. He also claims that the Public Defender's Office had input into the development of the policy. However, these claims are disputed by advocates who argue that their concerns have been consistently ignored. Hardicke also asserts that the DOC is not aware of any significant delays regarding legal mail and that the policy includes steps to protect confidentiality. But the experiences of attorneys and incarcerated individuals paint a very different picture. The DOC points to an increase in drug incidents before the policy's implementation, particularly the use of synthetic cannabinoids. They claim that paper and envelopes were being sprayed or soaked in drugs, posing a serious threat to the safety and security of the facilities. The DOC further claims that drug incidents have decreased since the implementation of the photocopying policy. They also assert that legal mail has tested positive for drugs in multiple incidents. This is a key part of their justification for the policy. The DOC also claims that individuals have been impersonating agencies to send drugs into the facilities. They argue that the policy is necessary to prevent these types of schemes. According to the DOC, the number of drug incidents involving legal mail has fallen to zero since the policy was implemented. However, there have been instances of false positive tests, raising serious questions about the reliability of the testing methods used. The DOC uses IonScan 600 testing technology, which has been known to yield false positive results. One investigation even used the same test used by the DOC and obtained a false positive. This raises concerns about the accuracy of the DOC's claims regarding drug incidents involving legal mail. If the testing technology is unreliable, the entire justification for the policy comes into question. Advocates have suggested alternative methods that could address the DOC's concerns without infringing on legal rights. These include implementing a verification method for legal mail to ensure it's coming from licensed attorneys. Other suggestions include changing the numbering system on envelopes to make it more difficult to impersonate legal agencies. Some attorneys have even offered to contact facilities beforehand when sending a client their file. These proactive measures could help prevent drug smuggling without compromising confidentiality. Another suggestion is for attorneys to call and verify that their office had sent mail to a resident. This simple step could help prevent fraudulent mail from entering the facilities. These alternative solutions offer a more balanced approach to addressing the DOC's concerns. Despite the DOC's claims, attorneys and incarcerated individuals report numerous instances of confidentiality breaches. Attorney Hurley argues that the moment a lawyer's mail is opened, someone is going to look at it. This is a fundamental violation of attorney-client privilege. Attorney Masnica argues that prison staff reviewing privileged communications creates a concern about the safety and security of incarcerated people. This is not just about legal rights. It's about the physical safety of individuals who are already vulnerable. Attorney Shakeshaft points out that there are opportunities during the copying and shredding of legal mail for someone to view the documents. This is a systemic problem that cannot be easily mitigated by cameras and specialized copiers. Attorney Welch cites a conduct report from when an incarcerated man was written up by a DOC staff member, suggesting that the staff had access to his legal mail. Attorney Skrzypczak expresses concerns that prison staff have had access to his legal mail for up to 3 days. Attorney Masnica also reports that the prison had reviewed the mail in detail. Attorneys report having to push back court deadlines due to delays in mail delivery. This is a direct consequence of the photocopying and shredding policy. Attorney York notes that clients need to sign documents, but the delays make it difficult to meet deadlines. York also reports that some clients are refusing to accept their mail due to the policy of copying and shredding. This is a drastic measure taken by individuals who feel their legal rights are being violated. Attorney Masnica reports that her firm has had to send mail multiple times because a client didn't receive it. This is a common complaint among attorneys who represent incarcerated individuals. One incarcerated individual, Story, reports an issue with not receiving mail that a client said they sent to him. Attorney Ferguson confirms that she sent mail to Story that didn't arrive. Attorney York notes that sending large files poses a risk of miscopying, further increasing the likelihood of lost or missing documents. The Wisconsin DOC's policy of photocopying and shredding legal mail is a dangerous infringement on fundamental legal rights. It undermines attorney-client privilege, delays access to justice, and creates opportunities for abuse. The DOC's justification, based on questionable testing methods and disputed claims of drug incidents, simply doesn't hold water. It's time to take action. Contact your Wisconsin state representatives and demand they investigate this policy and work to repeal it. Support organizations like the ACLU of Wisconsin and the Office of the State Public Defender in their efforts to protect the rights of incarcerated individuals. Share this video with your friends, family, and colleagues to raise awareness about this critical issue. We cannot allow the pursuit of security to come at the expense of justice. The rights of incarcerated individuals are not expendable. Demand accountability, demand transparency, and demand that Wisconsin prisons stop shredding justice.